Hello, good morning, everyone. Thank you for joining us for this CLE on free speech called Campus to the Courts, presented by the Muslim Legal Fund of America's Civil Litigation Department team. My name is Arub Ahmad, and I am a 3L at the SMU Dedman School of Law. We are going to get started soon, just going to give everyone a few seconds to join. If you've just joined the live stream, we are going to get started soon, just waiting for a couple of more people to trickle in. All right. Good morning, everyone. Thank you so much for joining us on this CLE Free Speech from Campus to the Courts presented by the Muslim Legal Fund of America's Civil Litigation Department. Again, my name is Arub Ahmad. I'm a 3L at the SMU Dedman School of Law, and I have the pleasure of moderating today's presentation. We are joined by the amazing attorneys Christina Jump, the Civil Litigation Department head, and Samira Elhosary, the Civil Litigation Department staff attorney. Christy and Samira will be discussing the recent developments in free speech rights, both for students returning to campus this semester, as well as students off campus. They will be discussing some of MLFA's cases and how they were using tools available under this administration and through the justice system to stand up for First Amendment rights. Before we get started, just to go over some quick housekeeping, this session is being live streamed and recorded. The CLE code will be available post live stream via email. So if you did not register for this event and we don't have your email, you can go ahead and register on our events page. And lastly, we will be having a Q&A session at the end. So if you have any questions, feel free to drop them in the chat throughout the presentation, and we will address them at the end. And now to introduce our two speakers. First, we have Christina Jump, again, the Civil Litigation Department head. Christy brings 30 years of litigation experience to MLFA at both the trial and appellate levels. Her practice involves civil constitutional cases, including challenges to the no-fly list and other government watch lists, land use and zoning law discrimination, religious discrimination in employment, religious accommodations in institutions, and defending denaturalization lawsuits on behalf of members of the Muslim community. Christy also served as an associate hearing officer for the city of Dallas for over 10 years and is an active member of the Dallas legal community. Christy and the civil litigation team challenge cases on behalf of our clients all the way to the Supreme Court, appearing as the lead counsel of record in cases where we filed petitions to the United States Supreme Court since 2019, and as lead counsel of record on an amicus brief to the Supreme Court in support of several other cases. We also are joined by Samira Elhosary, who represents MLFA's clients in federal courts nationwide, focusing on cases involving constitutional law and religious discrimination. Her practice particularly focuses on advocating for clients unfairly placed on the federal terrorist watch list or no-fly list. Samira also represents clients at all stages of litigation, from administrative proceedings through trial courts and in front of federal courts of appeals. In addition, Samira was recently admitted to practice before the Supreme Court of the United States. She also serves as a director at large for the National Association of Muslim Lawyers. Samira earned her JD from American University Washington College of Law in 2021, where she co-founded the AU Muslim Law Students Association and served as its first treasurer. These are our wonderful speakers, and before I hand it off to Christy, just wanted to remind everyone again that we will have a Q&A session at the end, so please drop your questions in the chat and we will address them. And without further ado, Christy, if you want to get us started on our presentation.
Great, thank you so much, and thank you, Arub. And I do also want to give Arub, as well as the Muslim Law Students Association, of which she is an active member at SMU Dedman School of Law, credit for doing a lot of volunteer work and helping us with our recent summit, as well as other events that we've had. And Arub has been an intern here before for us, so we think very highly of her, speak well, and we are honored to have her here with us today. So I want to go through we're going to do back to school recap. We're back in the fall session. Colleges are back into session, and a lot happened last year during the school year, and with protests on campuses and free speech coming under fire. And so we want to address what's happened, a little bit of recap, getting up to date. What has happened most recently, and how things are changing, if they're changing. So what you see here are some of the things that we're going to talk about on this first slide. We'll get into them momentarily. These show some of the things that we filed, some administrative and in courts as well. And so we'll talk about the actions that we and others are taking. We're also going to talk about some of the work being done by our colleagues with other organizations fighting many of the same legal issues. So if we could go to the next slide, please. All right, so before we get started, this is our team. This is our civil litigation team. And while Samira and I are the only ones presenting here today, it takes the entire team for us to be able to get anything done. So also pictured, even though not speaking today, is our civil litigation senior staff attorney, Chelsea Glover, who is in the photo next to me. Then we have Samira, our civil litigation staff attorney, Ms. Allie Boyd, and our civil litigation junior staff attorney, Janan Shahada, and our paralegal, who prefers that we not call her out publicly, so I won't do that, but I will mention that she's a very valuable member of our team. So we work to advance justice for Muslim organizations and individuals, as well as others who are unjustly targeted under the same legal issues that are of interest to our donors, to the communities that support us, and to the communities that we partner with. So you'll hear about how our civil litigation work oftentimes will bring multiple communities together or work on behalf of multiple communities. Majority of our work is for Muslim individuals and Muslim organizations, and you'll see that through what we talk about. Again, free speech for all means for all. So a lot of it is generally applicable or more widely applicable to many other targeted individuals and targeted organizations as well. So if we could go to the next slide, please. So we want to start by talking about what's going on campuses, and as you know, got an extreme amount of press last year from student protests and professors being targeted to students being targeted. And there's been a lot going on with campus and a lot of discussion about what is actually free speech. This is not an AI generated photo or stock photo, incidentally. This is from one of the cases where we are co-counsel with other organizations on behalf of students, and this was taken at the UT Austin campus. This is what happened when there's a protest there and arrests took place. So we'll also talk about how that involves the law. How do we attack this legally or protect the rights legally? And that comes from Title VI, which addresses educational institutions and what their rights are and their non-discrimination obligations as to all. And then also Title VII, which addresses employment. And we'll talk about that as far as the professors and also to some extent the students who are working in an employed context, as in they're working perhaps as teaching assistants or graduate assistants and have some work that they are doing as well in an employed context with the school that becomes implicated. And then we'll also go over so that people can know what to do, so that you know what to do as things come up. And you can give advice to clients if you're listening and you advise others so that you know what to do going forward. And if we could have the next slide, please, that'd be great. All right. So I want to recap, and this is the start of our most recent work. We've done work for years under Title VI and on behalf of students, but some of the most recent work more directly related to the events going on these days is the fact that we have Title VI complaint that we filed in January of 2024 on behalf of over a dozen students at Harvard. And those students had been targeted on campus in their buildings, in their dorms, in their classrooms for their speech, their activities, and for some just simply the way that they look, the way that they dressed, the presumptions that others made about them based on their religion and their national origin. So we filed a charge of discrimination with the Department of Education's Office of Civil Rights, which was subsequently investigated. And again, it was on behalf of this group of over a dozen students. This was not made broadly public. I mean, we did make public the fact that we did this. We did make public what the bases were of this, but we didn't make the students' names public because part of the issue that we were fighting was that these students were being targeted and having every bit of information about them become publicized, even if they hadn't consented to making themselves a subject of public scrutiny, even if they had never done anything public themselves and were just trying to go to class. So if we could go to the next slide, please. We'll be getting to the next slide in just a second here. But okay, oh, sorry. Go back to I just didn't recognize it at first. The one, there we go, thank you. Department of Education on that charge issued its findings in conjunction with other charges of discrimination that had been filed on behalf of other students. And there were Jewish students who filed charges of discrimination as well. And the Department of Education issued its findings on January 17th of 2025. So the last day of the last administration issued the Department of Education's Office of Civil Rights issued extensive findings and obtained a signed agreement that is public that was with Harvard and signed by Harvard. And in these findings, which we will provide, which we have links to on our website, we can provide those and make those available as well to anyone who would like them. But with that, and within the scope of its findings, the Department of Education found that Harvard failed to meet its obligations under Title VI to both its Muslim, Palestinian, Arab, and allied students, as well as its Jewish and Israeli students, and those allied with those students as well. Harvard failed to properly investigate the complaints that it received. Harvard failed to follow up on these complaints. Harvard failed to give information to these individuals as to what their resources were, what they could do to gain protection, how they could get safety, and Harvard failed to actually provide them a safe environment. So many things that Harvard agreed to in its settlement of this, its consent decree, really the settlement that it came as a result of this finding, many of the things that Harvard agreed to included updating its policies, not just its procedures, not just how it's going to implement them, but updating its policies and also updating its procedures and actually investigating complaints and not parsing out what considered a properly done complaint if it didn't come through exactly the right method with exactly the right magic words, because that's not the point. The students who complain, who ask for help, are not supposed to be attorneys. They're not supposed to know exact right magic words. If they're asking the university for help, the university should be giving it. So that was the outcome of that decision. And then if we can go to the next slide. Harvard then became the target with the new administration of the new administration. And Harvard had its funding frozen, a lot of funding frozen from the federal government for things that were completely unrelated. But the Trump administration said that because Harvard had a history of anti-Semitism, only addressing one category, that Harvard didn't deserve to get the federal funding that had already been promised for other purposes. Harvard fought back on this and filed a lawsuit. We filed an amicus brief, which is also called a friend of court brief. We filed that brief in support of Harvard's fight against what the administration was doing. We also made clear in our brief that Harvard had only told the court part of the story in its complaint. Harvard had talked about everything it's done for anti-Semitism. Harvard had talked about what it's been trying to do to rectify or to address complaints of anti-Semitism. It talked about its task force addressing anti-Semitism. It didn't talk about any other demographic at all. Harvard also had a task force that issued findings of its own, Harvard's own task force, that issued findings regarding Islamophobia, regarding anti-Muslim hate on campus and complaints. And that task force issued very similar findings that Harvard was failing there as well, much like the Department of Education did. So our amicus brief was to support the legal position of Harvard in challenging the Trump administration's punitive withholding of funds because it violated both the process and the intent of Title VI and other statutes, but also to inform the court that Harvard had this other obligation it had signed. It had multiple task forces, and Harvard had failed multiple categories of students. And so this was not just a myopic view on anti-Semitism. This needed to be a broader issue addressed. And what the administration was asking would only address one category of discrimination and one as to one group, not all, and not all of the areas where Harvard's own task force and the Department of Education had already found failures. So to provide an update of that, earlier this month, Harvard won summary judgment and a permanent injunction against the administration on many of the points that it raised. The administration claims that it is going to be appealing that and pursuing it and continuing to fight for its original penalties that it imposed. At the same time, Harvard and the administration are in discussions to try to resolve that. Some funding, as I understand it, has returned. It's happening quietly, but that's all still very much in development and not fully decided. And so an ultimate final decision on that is still yet to come. It's important to note that the judge's decision did not compliment Harvard and say, oh, poor Harvard, or, oh, Harvard's done everything right and the administration did everything wrong. As you can see here in the quote that is from the judge's opinion in this matter, the judge held that it is clear, even based solely on Harvard's own admissions, that Harvard has been plagued by anti-Semitism in recent years and could and should have done a better job of dealing with the issue. So Harvard doesn't get to say, we're on it, we're doing everything great, this is coming out of nowhere. Why would anybody dare question us or complain about us? The complaints are coming because something's wrong. That is true as to anti-Semitism. That is also true as to Islamophobia, and that is also true as to discrimination against other groups. The court did not address that, probably because that was not the scope of what Harvard challenged. So the court took the view of addressing what was in the complaint before it, what Harvard was addressing. But again, we raised that issue in our amicus brief, and we will continue to monitor and follow what happens with this case. If it goes on appeal, we'll do another amicus brief pointing out that Harvard's had failures of many of its groups of students and failed to protect many categories of students, not just one. So if we could go to the next slide, please. So on campus, we can see that professors have been targeted. These are some of the cases that we've handled and that we are currently handling. Some of these, if they are not publicly filed yet, we're not going into the exact names. One of these is for an adjunct professor in Florida. His employment had been terminated in that he had been teaching for years and had a couple of classes a semester for years that he was teaching. And he suddenly was taken off the schedule and told that it was because of his social media posts. Well, the social media post that allegedly formed the basis of this action was from many years ago, from when he was very young, and had been up there before he had been hired. He had not ever, denied it or tried to hide it or anything. But also, it didn't contain any threats. It was absolutely within the square realm of free speech. Didn't contain any threats. Didn't even contain hate speech. Supported an affinity group. And so he challenged and came to us, and we helped him challenge the fact that he had lost his employment for that. He was put back on the schedule, put back to work. It took some time. He is still actively working for that university now, but we do plan to proceed with further action for him because there are multiple semesters that he lost. So that's he still has the hard damages for that. And also, the way that it was handled broke the university's own procedures, didn't follow what it should have done, and through doing Freedom of Information Act requests and the like at the state level, we were able to determine that internally they knew that, and they did it anyway. So we also have been challenging on behalf of a Texas professor at a private university. We are working in conjunction with others where the Muslim professor was denied tenure despite a unanimous recommendation of the committee chosen to assess that. And despite her meeting every stated requirement for her department, she had been asked to participate in a Palestine-centric teach-in that had already been approved by the university to take place on that university's campus. And she did participate in that. Now, would have been totally fine if she had organized it. Turns out, though, she didn't even happen to be an organizer of it, but she was invited to speak at it and participate in it, and she did. And it was completely university sanctioned. But we believe because of that, based on comments from some of her colleagues and based on comments from the university, that alone led to the denial of her tenure, which again broke the procedures that are in place and the way that the university has handled this, handled evaluations of tenure for all others of any other nationality, of any other national origin. And then there are also professors who were arrested and threatened with discipline at the University of Texas at Dallas. We hope to have a complaint coming soon. There's a lot coming soon, but we hope to have a complaint coming shortly that will address this. We already filed a charge of discrimination administratively regarding some of this activity. And basically, multiple professors were arrested, did not have criminal charges brought against them ultimately. And nonetheless, they were threatened with discipline by the school. They were placed under restrictions by the school after they supported a peaceful student protest that had occurred on campus that was calling for a divestment and a ceasefire in Gaza. The professors faced discriminatory treatment afterwards based on their religion, their viewpoints, and their affiliation with pro-Palestine speech. And so that is what we are representing them for and working on behalf of. And then if we could go to the next slide, we'll talk about the flip side of this. So that was the professors. The work for the professors involves both Title VI and Title VII, as well as other statutes. And for students, we represent several students. We have done work on behalf of several students. And then also I want to talk about another recent case. It's not ours, but I want to mention it, that we're glad to see happening as well. University of Texas at Austin, we are co-counsel with ADC and multiple other co-counsel attorneys in a case brought against the University of Texas on behalf of multiple students. This image is from the complaint and is of one of the students who were targeted for pro-Palestinian peaceful advocacy, again, and peaceful speech by a greatly disproportionate law enforcement response to their protected speech in public areas that was consistent with Texas law. So they did everything according to both Texas law and according to campus laws. And there's actually in that case audio from a body cam of one of the officers saying, what are they doing wrong? Why are we arresting them? But we've been told to go arrest people and we've got a quota. So let's go find someone to arrest. Which one? That one. Okay, let's arrest that one. And that is almost verbatim of the actual transcript from the body cam. It's set forth in the complaint, which is on file. The defendants, the state of Texas and the UT system filed to try to dismiss that, but we filed a response just yesterday, along obviously led by our co-counsel at ADC and our other co-counsel opposing that dismissal. because there are, at best, all kinds of fact issues that need discovery. And we believe really clearly discriminatory intent that was shown. And then the last one that I want to talk about here is an action against the University of Texas system-wide. This is a lawsuit that was filed recently by FIRE, so the Foundation for Individual Rights and Expression, I believe, if I'm getting that acronym correctly. But this was filed. This lawsuit was filed by FIRE on behalf of multiple student groups, as reflected in that caption right there, and they are challenging a new Texas law that just went into place that prevents any kind of gathering from 10 p.m. to 8 a.m. and prevents gatherings during the last 2 weeks of the semester during any hour. So there's multiple free rights issues that are addressed by that are harmed by that. And so that's one thing that we are very glad to see FIRE taking this lawsuit on behalf of the UT students, again, system-wide. And this is FIRE's lawsuit is on behalf of multiple student groups of many different faiths and some that are not even religiously centered, but they're pointing out how their free speech is being impeded by the state of Texas and by the UT system. So we could go to the next slide, please. Right. And so I want to talk, I was about to hand it over to Samira. I forgot I got one more to go. Okay. So in this one, students have been targeted as well. These are, again, lawsuits that we want to point out because they're on the same issues, even though not brought necessarily by our organization, but they show the broader issues. Students sued the Department of Defense schools. So for military bases, there's a Department of Defense school system, and there was censorship that was beginning. Books were being pulled, curricula being changed to tailor it very narrowly to this particular administration's preferences. And many students brought a challenge to that. The ACLU is representing them in that, and we're going to be watching that one closely as well. And that's challenging free speech. It's on a different type of campus. It's curious and interesting, particularly because it's the Department of Defense school system. And then UC Berkeley has made the news quite recently. Student and faculty names were provided by UC Berkeley to the Trump administration officials. And it appears, this is all still developing, that it was in retaliation for the Department of Education's, or in relation to, the Department of Education's investigation over allegations of anti-Semitism, and there are allegations that what was provided is in retaliation to free speech expressions by those students and by those professors. We'll be watching that closely. That may be something where, in the right time, in the right scope, we may be joining in an amicus to fight with that as well. That is very recent and definitely still developing. So free speech remains very much under attack on campuses. And now if we could go to the next slide. I want to pass this to my very able colleague, Samira Elhosary.
All right. Thank you, Christy. And my apologies. I have a little bit of a cold. So if I cough a little bit, I'm sorry. So I'm going to be talking about a few of our cases that are related to free speech issues that are not necessarily related to students on campus. So we've definitely seen an uptick in lawsuits targeting free speech and targeting people for their use of social media. But then we've also seen on the other side a lot of success in fighting back against those lawsuits, and in particular using state anti-SLAPP statutes, which I can get into a little bit in a couple slides. And then we're just going to go in. I'm going to go in a little bit into what to do and how to protect yourself and protect your clients when these cases come up. So next slide. So we are fortunately winning across jurisdictions. And then these are two cases in particular that I want to highlight. So the Muslim Legal Fund of America, we represent the organization American Muslims for Palestine, which is one of the largest nonprofits advocating for Palestine in the US, and has, because of that work, been targeted in a lot of ways by lawsuits that attempt to hold them liable for various harms under different federal and state statutes. So this map here shows the current pending cases against AMP and that we represent them in. And then recently we've won 2 in District of Nevada and the Eastern District of Virginia, definitely hoping that this is a pattern. And so I'm going to go into those in a little bit more detail. So next slide, please. So Eastern District of Virginia, this was one of the first lawsuits that were filed against American Muslims for Palestine. It was brought by several individuals, both U.S. citizens and non-U.S. citizens who faced harms from Hamas's October 7th terrorist attack and subsequent acts that happened in Israel. So essentially what this lawsuit sought to do was to hold AMP and others liable as the propaganda arm of Hamas in the US. And their evidence for that was simply AMP and others' advocacy for Palestine and free speech for Palestine. So we obviously moved to dismiss this claim. We asked the court, rewind a little bit, it was brought under the Anti-Terrorism Act, the ATA, for the US citizens, and the Alien Tort Statute for the non-US citizens. So the court dismissed all of those claims in full, and around 33 days ago, and gave the plaintiffs 30 days to amend their complaint, and they did not do so. So we are now looking forward to a final judgment and being done with this case, and very grateful because a lot of the subsequent cases against AMP related back to Pariser. And so being able to say that the judge here found all of these allegations to have no basis will be really helpful going forward. So really excited to see that one. Next slide, please. And another big win for us recently and for AMP was in the District of Nevada, where an individual student, a Jewish student at the University of Las Vegas at Nevada, he claimed he brought a lawsuit against AMP, again under the ATA, for harms actually that he faced in Nevada on campus. And so if you know anything about the Anti-Terrorism Act, which requires that somebody be harmed by an act of international terrorism, you can kind of see that this is starting to kind of not make sense. So we got that claim dismissed, and in this case, he did amend, but in that amendment, he didn't make a lot of changes. And so we've now moved to dismiss again and for sanctions. And a lot of the statements and the allegations in this lawsuit were again based on AMP's speech and social media and advocacy for Palestine, and saying that that led to protests on campus that led to harm for the plaintiff here. So we were glad to see that very tenuous connection was ultimately discredited by the court, and hoping for a positive outcome on the amended complaint as well. So next slide, please. Yeah, so to kind of wrap it up, what works? Obviously, I think one thing that's been really helpful is remembering, that in a lot of cases, our client is in the right. They are advocating for free speech, and you just continuing to defend free speech. And we're glad to see that courts are seeing that, both in the 2 cases that I referred to and in some other cases that are not handled by MLFA. So we're seeing a really positive trend going forward, I think. And then, what does not work? One thing we've been trying to do is really continue to keep the higher ground. These allegations are hurtful to our clients, and calling them terrorists, calling them all of these negative things, but continuing to remember that we have the higher ground here. And yeah, so what's next? We hope to see this trend continue, and more cases that are based on speech get dismissed, and knowing what to do. So we can go into a little bit more about what we recommend that people do as far as speech and doxing. But yeah, so I think that is everything I had, which is a little bit faster than I anticipated, but hopefully we have lots of questions.
Before we get to the questions, I will throw in here just to add a little bit more on this portion that we do have resources available on our website that, again, we can provide links to after this, and we can let people know, where we have like one-pagers that may be helpful for education, where to follow some of the cases that we referenced if you want to track those. And we have up here also a couple of the things that we want to mention are, what does work and what does not work. And as Samira mentioned, we're seeing some good trends, and it's not just with our cases. We've seen some other cases that have dismissed similar lawsuits as what we've talked about as well, where individuals have been who were targeted for things that were very much beyond their control, and where the targeting was based almost strictly on just free speech, and oftentimes even just in social media. The courts found that that's just not enough. That's not anything that establishes liability, even civil liability.
And I forgot to talk about the anti-slap that I said I was going to talk about.
Go ahead.
So in the case in Nevada, so one issue that we were seeing was that a lot of these cases were brought under federal statutes. But then we also started seeing claims brought under state statutes. Like in Nevada, they also brought an intentional infliction of emotional distress claim. And in that case, when we're looking at a state law claim, many, if not all states have anti-SLAPP statutes, and that stands for Strategic Litigation Against Public Participation. I think that's correct. And so these anti-SLAPP statutes basically create a mechanism for individuals to challenge lawsuits that are brought for the purpose of silencing speech. And most federal courts have found that those statutes can only be applied to state law claims. So we were able to bring a challenge under Nevada's anti-SLAPP statute to that intentional infliction of emotional distress claim, and we won on that. And we are pending an order on the amount of fees that we may win as attorneys' fees in that. But it's a really great way for people who are for attorneys who are dealing with cases that are trying to silence speech. We definitely think it's a good idea to look into your state's anti-SLAPP statute and try and bring claims under that, because they are meant to deter these lawsuits that are to silence speech. And so it's really important that we use those tools that we have and create that deterrent effect so that we don't see this continuing to happen.
Absolutely. And that's one of the things that we want to establish, as well as one of the things that we've seen, what does not work. What does not work is trying to pretend it's not there, trying to ignore it, not challenging this kind of behavior. It did not work when individuals who were targeted just went silent. That didn't stop the attacks, that didn't stop the targeting. And so they continued to be targeted. And again, many of our clients, some are being targeted for things that they've said on social media, many of them, and many others are simply being targeted because of how others perceive them, even without social media statements that others happen to disagree with. That social media speech is protected. It is protected activity unless it calls for violence against a specific individual. and an imminent or is an imminent threat against an identifiable individual with an immediate threat for imminent harm. Short of that, it's protected free speech. Others are welcome to disagree, and they can. They don't have to like it, but it doesn't make it illegal that they don't like it, and it doesn't make it actionable. So doing nothing is one of the things that we've seen does not work. Retreating, purely retreating, and hoping it'll blow over does not work. It has not blown over at all. Where we see progress is where people challenge these actions, where people challenge the suppression of free speech. That's where the schools back off, at least somewhat, from at least most of them. That's where the schools recognize that perhaps this isn't a one-sided view. Perhaps they have funders, they have donors who don't agree with restrictive actions. And then when we talk about know what to do, again, we have on our website, and we can make available in what we send out subsequently with the CLE information and to any registrants, references to our resources that are available on our webpage. You can see here on our YouTube page that there are multiple other videos that we've done, training videos, so feel free to peruse those, take a look at those and see what applies. And we'd be glad to provide additional educational materials to anybody who would like them. And with that, I will hand it back to our moderator.
Thank you so much, Christy and Samira, for that excellent presentation. Definitely very informative on a very, very important current relevant issue. We're now going to be moving into our Q&A portion. So again, if any viewers have any questions, feel free to drop them in the chat and we will address them. But Christy, one thing that I wanted to ask, a few moments ago, you talked about some of the trends in these current cases. So just wanted to talk a little bit more about that. So on the campus side with students, as you discussed, Christy, and then even on the non-campus, non-student side, as you discussed, Samira, overall with free speech, what trends are both of you seeing in how these cases are popping up?
I can take part of that to speak, and then Samira, if you want to join in with anything I miss or anything that you want to add. One of the things that we're seeing is, as Samira mentioned, there's been a pivot for some of these lawsuits that were brought under federal statutes, trying to claim a civil version of material support of terrorism simply for using pro-Palestinian speech or this has happened a lot with groups like JVP and student members of those groups as well, which is Jewish Voice for Peace. So there have been federal statutes being used in the civil context, claiming that those are representative of material support of terrorism, simply because they are opposing views to some here or to the groups that bring them or the individuals that bring these lawsuits. That is not the case. And with the courts starting to issue holdings, multiple holdings in multiple jurisdictions, making clear that regardless of what these other groups may think, of particular affinity groups may think, or whatever these other individuals may think, that that's not what those statutes were designed for, and that's not covered. We're seeing the pivot then to state claims, like Samira mentioned. And so instead of being, for example, a civil claim under the civil provisions of the Anti-Terrorism Act, claiming that somebody is supporting terrorism by making an Instagram post or a LinkedIn post, what we're starting to see now is claims for tort damages under state laws, under state statutes, under state causes of action that are a little softer. Things like defamation, conspiracy to defame, other things along those lines that fall within the state rubric. And those, I think, we believe that the pivot is because they're thinking, well, okay, if we didn't win on the statutes, then let's see if we can win on these, where it's a little murkier. And that's where, like Samira mentioned, the anti-SLAPP statute actions come in. Those can be done sometimes if it's on a state statute or on a state cause of action. Even if the lawsuit's filed in federal court, it can be done there. Otherwise, the anti-SLAPP statutes can be used in almost every state court against state court causes of action. So we're seeing that pivot, and we're also seeing more of a group or a unified targeting of negative complaints, negative comments online regarding somebody's place of work, going after specific individuals, but in concert. So a large group deciding, okay, now we're going to target this one person and put a whole bunch of comments, or go to their employer and tell their employer this one person is wrong, is awful, is evil, whatever. And so that requires employers being well informed as to what the rights are of their individual employees, as well as what the employer's rights are. And we're glad to provide information on that. And it also requires those individuals to double check, make sure that they are within the realms of free speech. And so far, from what we've seen, majority of them are. And then, decide how they want to handle it. And Samira, if there's anything that you want to add to that, I'm going to turn it over to you. Feel free to.
Yeah, I think one trend that we have been seeing and is continuing is if you think back to that map that was on a slide a few slides ago, you see cases that are popping up all over the country. And we know that this is on purpose, and that these groups that are funding these litigations, because we know that there are individual plaintiffs, but they're supported and brought by interest groups and big amounts of money that are being funneled into bringing these lawsuits. And they're bringing it across the country for the purpose of trying to create what's called a circuit split, where different courts in different parts of the country hold different ways. And if they can get a circuit split created, that's the kind of case that the Supreme Court would be interested in looking at. And so what we believe they were trying to do is create that circuit split. Fortunately, we're seeing courts coming out the same way again and again. But they're trying to drain resources as well. So they're trying to bring these groups, these pro-Palestine advocacy groups, into courts all over the country. They have to get lawyers all over the country. They have to be in courts all over the country, and that drains resources. So that trend of popping up in different places all over is super purposeful. And we're continuing to see that happen. And even when it's the same groups of attorneys that are filing it across the country. So that's one trend.
Thank you so much. And just to continue on this line of questioning with trends. So we talked a little bit about trends in how these cases are popping up. So on the flip side of that, what trends are both of you seeing in how free speech cases are being resolved?
Yeah. Samira, you want to start?
Sure, yeah. Like I said, we're definitely seeing the courts holding again and again that speech is not enough to hold someone liable for different tort actions. They're asking people to, they're requiring that plaintiffs show actions, show acts, show money being transferred, show people being working in different places. Speech is not enough. Social media posts are not enough. And luckily, we're seeing courts find that. We are seeing amendments in a couple of cases that the courts have then allowed to go forward. But, those amendments are showing some more tangible acts. Whether or not I agree that reaches the level of material support at the civil context or the other statutes. But speech itself is again and again being found insufficient to support federal and state lawsuits.
I agree. And I think a lot of what, again, we're going to continue to see is, as Samira mentioned, in order to have the lawsuit survive, they need to be more specific, less general. There's a lot of the blanket copy and paste language that has been used in many of these lawsuits, even if not by the same attorneys bringing them. It still is the copied and pasted language from other lawsuits that other attorneys have filed, listing a lot of generalities, and the judges simply do not like that, and they're not giving that much credence. They're not giving that much daylight. So the specifics are coming up, which is as it should be. If there are specific ways that individuals have been harmed here, that's what the courts are meant to address, to see if there's anything that falls within a covered statute or cause of action. What we also then expect to see for the pivot is that in response to that, what they may be doing, what individuals may be doing instead, if they decide, okay, so that lawsuit formula that we were doing isn't working, isn't going the way that we want or getting the traction that we want. So instead, what we're going to do is go more local. And by going more local, it may be more targeting on a particular campus, going to the particular administrations. There's a lot of that happening now, going to the specific administrations, very much like going to an individual's employer and, you know, pulling somebody's TV show because they said something unpopular. That type of thing is what we're seeing as the pivot, even on a much more municipal, local, community level. And again, the way to handle that is to not hope it goes away, because it won't just go away. To be able to challenge it, gather others to help challenge it, seek information or seek guidance on how to challenge it, and be ready to push back, because it'll just gain more steam if it's not challenged.
Thank you both for that insight. And just want to remind folks to drop any questions you have in the comments. And if you are having trouble, make sure you're logged into your account on YouTube to be able to drop your questions. And now changing topics just a little bit. I know a lot of students, a lot of folks are concerned with, maybe advocating for certain platforms and policies, given that free speech is under attack nowadays. So, Christy and Samira, can you just give us some insight into what protections students and professors actually have when facing discipline for speech?
Samira, you want to start?
You can have it, Christy.
Okay. So I would say, first of all, there is protection absolutely for the speech. Understand that the universities, to a degree, can establish policies for campus safety as long as they're applied consistently, as long as they're applied across the board the same way for example, all presentations, all events, all gatherings, all free speech. You know, if there's a restriction that we don't want anybody, holding a gathering in these specific buildings, and uniformly there isn't a gathering held in those specific buildings, then that's all right within the power of the schools to do. So make sure that you're up to date on your specific university's policies, most up to date policies. And those may not be in the materials that you were given at the start of the year. So make sure that you're going to the website, clicking through and looking if there's an intranet, if there's a blue link or whatever each individual school may call it. Make sure that you're double checking to see whether there have been any updates that have been sent out, and check those. And if you have that information, if you have that knowledge, then even if you are approached by somebody who says, hey, you can't say this, you can say, actually, I checked the policies, and this is in accordance with the policies and procedures last issued by the school on September 2nd or whatever date. So if you know that information, feel free to do that. There is also a protection to speak anonymously. That should not be necessary. Individuals absolutely have the right to speak in their own names, but for those who may be concerned for their safety and don't want to put their safety at risk, we're certainly not going to mention that, not going to advise that anybody be the one to stand up and put your own personal safety at risk. If you're not comfortable doing that in a way where you may feel truly threatened, then don't. But you can make anonymous posts. That is allowed. Check to see too, universities, we noticed at the start of this year, had been revising their policies. They may have a chalking policy now, which I still giggle at because it's new. And it's a new form of restriction on free speech. But see if your university has, or your place of work, if it's outside on the property, has a chalking policy restriction on, for example, writing things in sidewalk chalk. If there's not a restriction, it's okay to do. If there is a restriction, make sure that you're following and aware of it and know what it is, or know specifically what you are challenging if you make the decision to challenge. And then we do have, again, other YouTube videos which are in place of how to protect yourself if you are going to protest. If you want to protest, which is your protected constitutional right, make sure that you're being smart about it. Make sure that you have researched the specific rules for where you are, not just the general constitutional rights. Make sure that somebody knows that you're going. Make sure that you have, a fail-safe in place. Like, you're supposed to check in by a given time, and make sure that you do. If you don't, somebody knows who to contact, and make sure that, you have consulted. You can also contact other organizations like National Lawyers Guild, which does provide neutral legal watchers for a lot of events. We as an organization do not do that, but that is a service that's available through referrals through the National Lawyers Guild that will do that. And that's a good thing to have. You can have a free speech legal watcher. There's a legal observer. Thank you. Legal observer, not stalker, but legal observer who will be available. And those people cannot and do not participate in any actual protests or events that are taking place, but they'll be there to observe, to take note, to be able to report later on what they saw. They usually are wearing something that designates them as a legal observer. And it's good to have that in mind. Samira, anything you want to add?
Yeah, I think on the non-student context, if we're talking about organizations and employees of different places, private employers, related to what Christy said, know your rights, know your employer's policies, know the law that surrounds what you want to do. We always recommend speaking to an attorney, whether it's MLFA or any other organization that provides legal assistance, and just understanding where you're within your rights. And there's a lot of misinformation, especially right now, especially around free speech. There's a lot of misinformation about what people can and can't say. So just getting that opinion from a lawyer that to make sure that you're protected, and just feeling empowered that you're going out and speaking your mind and advocating for your values in a way that is protected and safe.
Perfect. Thank you so much, Samira. And that is a great segue into a question that we got from the public. So what about students who are already being expelled and or suspended? What is the best way to complain or fight back without amazing legal representation like MLFA?
Legal representation is always great, but another thing to do, again, first of all, make sure that you know the rules for that particular playground, so to speak. Make sure that you know the administrative procedure and the administrative steps for that specific university's process. For all of those processes where a student might be under disciplinary threats or under a disciplinary investigation that may affect their degree, may affect other things. Make sure that you've checked the policies and procedures really detailed on those, because chances are the specific university individuals may not know them all that well. And if you do, that gives you a great advantage. So check for those. You can also consult with legal organizations. There can be an intake done, through us at MLFA.org, and you can click the links to follow through for that. There also can be, there are other specific local organizations usually that may be, community organizations. There may be someone who practices in your specific state who can give more information if you are accused of having broken a state law or state ordinance or local ordinance. So double check and see what's happened. But also, I would advise too, check what's happened recently. Check the history of what the school has and has not allowed, and check to see if you can find a comparison of somebody who did the same thing, took the same kinds of actions, another student group, another student, somebody else who was in, say, the same place, doing the same type of thing and was not disciplined. And if you have a comparator like that you can point to, that'll get you a long way.
Thank you so much, Christy. And we have one last question. I know we're short on time. We have about 2 minutes left. So we could just get a brief answer to our very last question, again, from the public. Do you expect a change in the climate on campuses this year as compared to years past?
Samira?
My very non-legal vote is no. I think we've seen a lot of students really continue to advocate for their values and continue to speak up. And I have every reason to believe we're going to continue seeing that.
And I'll add that I think there's a lot of fear, and it's well-grounded from students on campuses. There's also a lot more awareness. So use that awareness. Be ready to do what you want to do. There's lots of ways to fight back. It may not be carrying a sign or holding a microphone. Maybe you're the one who writes an op-ed. Maybe you're the one who makes posters because you do art really well. There are a lot of different ways to do your part and do whatever you want to do. So with schools like Harvard fighting back, it's got a lot left to learn, but that helps.
Thank you both so much again for your insight and for that powerful ending. Thank you again, everyone, for joining us today. Just want to quickly remind everyone that we will be sending out the CLE code via email. So if you did not register for this event and we don't have your email, you can go ahead and register now on our events page. And we also want to remind everyone of MLFA's upcoming annual banquet. It will be on October 18th in Frisco, Texas. You can visit MLFA.org to learn more. Our keynote speaker is Noura Erakat. So she's incredible, very well-known and renowned legal scholar, activist, and attorney. So it will be a great event, and we hope to see many of you there. But thank you again, everyone, for joining today's CLE. And thank you, Samira and Christy, for your presentation.
Thank
Thanks,
you.
everyone.
Thank you, Arub, and thanks everyone for joining.